Welcome, everyone. My name is Dimitri Iliopoulos, and we're excited to have you join us today. Today, we'll be discussing asset protection considerations for physicians. This is one of the most popular educational topics for physicians and one that is the most requested of our team. It is a very relevant topic. It's often overlooked. Sometimes it's deemed to be too complicated, and because of that, thinking about it and making decisions about it typically get put off. But the reality is we live in a very litigious world, and proper asset protection planning is hugely important. So we're glad you're with us today. We hope you learn a lot from our presentation. Before I introduce my colleagues, I just wanted to cover a few housekeeping items. Number one, your sound and video are turned off during this webinar, so there's no need to worry about that. Feel free to submit questions as we go. Typically, we find that when you have a question that comes to mind, it's best that you submit it in the Q&A section that you see at the bottom of the page here, and we'll do our very best to address them either during the presentation or at the end during Q&A. And then we've also received several questions in advance of today's topic discussion, so we look forward to addressing those with you. So I'll start with introducing our team. I'm Dimitri Iliopoulos. I serve as the Chief Executive Officer of Curi Capital. I have a simple role today, and that is to moderate and facilitate this discussion with two of our very talented colleagues, Frances Cronlin and Jason Largy. Frances is a Senior Vice President and a Senior Wealth Advisor. She has over 3 decades of wealth management experience. She's been working with physicians for over 15 years. She's a certified financial planner charter holder, a certified investment management analyst, a certified trust and fiduciary advisor, and a certified exit planner. Jason Largy is a Senior Vice President and wealth strategist. He has deep expertise advising our clients and our teams on wealth preservation and estate planning goals. He started his career in the U.S. Air Force JAG Corps. Jason, as always, thank you for serving our country, and then transitioned to practice as a civil litigation attorney, focusing on probate and estate planning law. In 2014, Jason transitioned to wealth management, but he still has a membership in the Colorado Bar Association and with the Denver Estate Planning Council. At the end of today's presentation, we will share Frances and Jason's contact information if you'd like to set up a conversation with each of them individually. On the next slide, you'll see who we are. The Curi organization has been serving physicians and healthcare providers for 50 years. We're celebrating our 50th anniversary this year. And that's important because it has given us a very deep understanding around the world of physicians, the challenges you face, the opportunities you have, and with regard to our subject matter expertise, the complexities you all face with regard to financial planning. And thanks to everything that we've gathered and learned from all the physicians that we've worked with over the years, we're really excited to share this content with you today. So this presentation is designed for you, and we hope you get a lot out of it. On the next slide, you'll see a snapshot of our firm. I'm responsible, grateful, and proud to be leading an organization of nearly 180 employees around the country. We serve over 3,000 families across the United States. We have 10 offices in 8 states, and today we oversee approximately $14 billion in client assets. And because of the great work from our team, we are perennially ranked as one of the top 100 registered investment advisors in the country. So I will come back towards the end to help facilitate some of the Q&A, but now we're going to dive into the topic, and I'm going to turn things over to Jason Largy. Jason?
Thank you, Dimitri, and thanks for everyone attending today's webinar. We start with this slide. It's probably one of the reasons you might have registered for this. I like to quote Willie Sutton, because that's where the money is, or in particular, it's where popular society believes that physicians have wealth. And it's just interesting when I'll even think about like conversations amongst friends or family. Sometimes you'll hear someone say, "Oh, you had a bad outcome, at a in a medical situation, and are you going to sue?" And we're so well conditioned, or society is, to do that. That's, I think, why physicians are a target. One of the things that Dimitri mentioned in my background, mentioned litigation, actually was a medical malpractice or professional liability defense attorney out here in Colorado for about 6 years before switching over to more of an estate planning focus. And the probably the number one thing that would happen for the clients that the law firm I worked at was and the thought about asset protection. And one thing we'll mention here as we go on is that no no one circumstance is the same. So what might work for one family or for one client when you're thinking about how to protect assets might be completely different based on your goals, who's in your world, what assets you've accumulated, and the types of assets that you have. So that's why what Francis and I are going to try to do today is kind of go through and give a broad sketch and hopefully give some ideas of some things you can focus on going forward.
Thank you so much, Jason. As Jason mentioned, he's an attorney. He's not your attorney, though. So everything we say today is for you to take back to your attorney for legal advice for your particular situation. So let's take a look at the next slide, which speaks to exactly how do we start the process of asset protection for a physician when this is what they're up against. This is the accumulation of assets timeline that physicians face. So we all know early in a physician's career, while they're accumulating some education, sometimes they're also accumulating a lot of debt. And the initial focus after career is, how do I bother to accumulate wealth while I'm also trying to pay down debt, which is a distraction for a lot of physicians, understandably. And that distraction prevents them sometimes from understanding that the best time to prepare your assets for protection is each and every year that you are accumulating wealth. So actually today, the question I received was, I just retired. Now I'd like to do asset protection, Francis. How do I go about doing that? And that's a really tough situation because truly, this physician who asked me that question is in wealth preservation mode at this time on the timeline. They are no longer in wealth accumulation mode. And some of the most powerful tools that exist to prepare assets for their optimal protection is every single year maxing out every type of retirement plan available to you. And sometimes those have annual limits, and sometimes those annual limits have calendar deadlines. And so it's not as simple as, great, I'm so glad you've accumulated millions of dollars in your personal brokerage account. Unfortunately, you're not able to just transfer all that to your IRA in kind. That's not a possibility. So a lot of the opportunities that exist, and that's just one of the strategies that exist to protect wealth, are actually timeline specific. So early and often, as we often say with so many things that are good for us, we need to address asset protection along the way. Now, next we're going to have Jason talk about why it is and how it is that we can prioritize avoiding litigation and doing asset protection at the same time. So let's go to the next slide and have Jason speak on that.
Thanks, Francis. Yeah, to the extent if you've hopefully not had to experience any type of litigation, it's a bit of a process. It's a lot of hurry up and wait. As I mentioned, I was like second chair for I think it was about 6 actual cases that went to trial. And the statistics bear out where a lot of cases, the majority would get dismissed, or, sometimes there would be a potential for a settlement. And then, sometimes when there's mediation, of course, is mandatory in a lot of states. So, there aren't that many cases that actually get to trial, and much more cases that actually get to a verdict that is in favor of the plaintiff. So, one of the things is to, take a look at all the circumstances, and we'll get to that. When we put together this timeline, our thoughts were, okay, well, something happens that causes someone to want to file suit. And one of the first things is if there's a doctrine called the fraudulent transfer doctrine, which means if you're on notice that a suit is pending or going to, that there's a claim pending, it's too late to move the assets. Those could be potentially clawed back. So one of the reasons that, Francis said in that timeline, as you're building wealth and at the earlier stage of accumulating assets, it's a good idea to make sure things are titled correctly and, put into the right buckets and all the things that are going to be important for you. The best out of there was an ex-plaintiff attorney who worked in our defense shop who said that, he used to call the great expectation letter was the letter that like a plaintiff's attorney would send, to the physician, typically to their malpractice company, and then it would make it to the defense attorney's shop. And that was always like the best version of the story because it was all the facts, everything was in, the plaintiff's point of view and sounded great. And that's when the clock starts. Usually it starts to chip away after that. But in the discovery phase there in the middle, that's where the plaintiff and their counsel can request and receive financial statements and data to show what is available. And so that's where you can also, you might have to identify what the policy limits are for the various insurance that you may have and so on. And then, of course, the case, goes on and might settle, might dismiss. And then, obviously, hopefully, if it gets that far, you'd hope for a defense verdict, which, from my experience and just anecdotally know that the defense verdict is, typically a lot higher. So that's, a bit of the timeline of a case. And one story that I like to share is in between the discovery and defense verdict, we were representing an OBGYN that had a real bad outcome where an expectant mother and that was carrying twins passed away, and as did the twins that were to be delivered. And so there was a really rough wrongful death lawsuit, and multiple times throughout the representation, we kind of talked through like if you have an insurance policy, in this case it was a $1 million insurance policy, and we talked about the various assets, and that's what we're about to get to in the next slide, that were potentially off limits for a plaintiff if there was a verdict in excess of the insurance policy, because the jury isn't told what the insurance policy would be. That would be prejudicial because they might just go right to that number. And so, it was really tricky to have to talk to that physician to say, here's the assets and that was too late for an asset protection plan. It was more of, these are the assets that are potentially available. At the time in Colorado, you could only shield about 120,000 or so of your exemption on your personal residence. And then you can go through all the other assets. So we'll talk about all those, but that one physician, luckily, shortly after that, the case ended up being dismissed on a great technicality in the physician's favor. So we never had to go that far. But those are the types of things that obviously can keep people up late at night, and why we're going to go through the different types of assets that are and how we look at them when we're helping our clients.
Thanks, Jason. And I'll mention that at step 1 and at step 2, if you go through our litigation education series on the Curi Insurance website, I think it's a 15 or 16 part series where you can educate yourself about the entire process and what to expect. What I come back to over and over again is a lot of the damage that happens psychologically to a physician and their well-being happens not just after the adverse event, but also the notice of claim too. And so even if in Jason's story, the case ended up getting dropped, the damage that gets done to you psychologically that adds to your burnout and makes you start to wonder, why am I even practicing medicine anyway? This is frustrating and scary. Can say, hey, look, at least if you have done all of your asset protection and it is up to date well in advance of an adverse event or a notice of claim, you can tell yourself, you can tell your family, I know that I've done all that I can do at this time, so I am protected. And I might point out this fraudulent transfer doctrine issue of, you can't, after an adverse event, if you start moving assets around, that can lead, unfortunately, to suspicion that you knew something was wrong. Just the same as in our litigation education series, we remind everybody, don't go access the chart. Don't go looking things up. Don't even log on to it, especially if there's been a notice of claim. If there's a concern, then call your malpractice insurance provider for some good old-fashioned, risk management counseling. But I just cannot say enough about how often I'm talking to physicians who they have not had an adverse event lately, but they've heard about another physician who did, and then that's what's motivated them to come speak with me. So on our next slide, we're going to talk about some of the typical solutions that a lot of physicians use and that are perfectly fine in order to help minimize the risk that they have assets available, in their own name that would go to pay a claim, should there be one to pay above and beyond your malpractice insurance. So obviously you need to maintain adequate malpractice insurance. So reminder, I call it here liability insurance. It doesn't have to just be malpractice. It can be auto insurance, homeowners insurance, boat insurance, errors and omissions insurance as related to business activity, anything that pays a claim for you. Maintain an adequate amount there. Adequate is a key word, and we will get to what is an adequate amount. Another is having a secondary liability policy. So having an umbrella policy in addition to your automobile policy, in addition to your homeowners and your boat and your jet ski and all the other toy type of assets. So having that secondary policy too. In many states, it makes perfect sense to title assets in your spouse's name. That generally means you still have control and access to those assets, although I think sometimes folks kind of question if that's going to happen. So titling assets in your spouse's name is also an option, assuming your spouse is not also in a high-risk profession like medicine or another profession that puts them in harm's way as it relates to liability. We talked about this earlier, and I'll repeat it again before the half hour's out. Max out investments to your 401ks, your IRAs, or other workplace retirement plans. Also, and this gets back to the earlier topic I had about the timeline for physicians, investing inside a life insurance contract in some states allows for protection of those investments. So there are some states that are not the case, where investing inside a life insurance contract allows, or an annuity contract, allows those investments to be hands off as it relates. And sometimes it's not insurance contracts per se, it's just who's the beneficiary and who's the owner of the life insurance contract that makes all the difference in the world. So that's the fine tooth comb work that really you're best to sit with a professional to get that done right. And then finally, placing assets in some sort of an LLC oftentimes makes sense too, particularly if you have a rental property or a business property of some type that has a business purpose. Putting it inside of an LLC at least makes sure that if somebody slips and falls on that rental property or at that business, then at least when they sue for recovery, they're suing the LLC. They're not suing you personally because you don't own that rental property. You don't own that business asset. The LLC does. So this is probably the most frequent, lowest cost, easy to implement type of solutions that exist to do some kind of asset protection planning. And next, we're going to have Jason talk about, if we had a wish list of everything when we were shopping around for a list of asset protection strategies, what we would look for. So let's switch to that slide and talk about that next, Jason.
Yeah. When you think we put this together about a wish list, when you earn and have assets that are yours, you like the idea that you can control those assets and use and enjoy them. And we kind of put that at the top because some of the more complex strategies can take away from that control and use and enjoyment. So, an easy example is I also work and focus on the estate and legacy planning for our clients. And if you make a large gift of some of your assets to charity or to one of your heirs, it's no longer yours. So if you did it within a period of time and it wasn't done so as to avoid a claim, it's not yours anymore, and you can't have someone give it back for you to give to a creditor, like a plaintiff with a verdict. Of course, you might want to hold on to those, and I get it. And most of the families we work with, they want to maintain that type of control. Um, the the protection is important, and one of the things I know Francis mentions it a lot is we do have to take a look, because sometimes it's not just the potential plaintiff in a medical case. It could be a potential divorce, or it could be a business partner. There are other ways that you might have a creditor that you weren't suspecting. So as you're thinking about things, that's where any chance to create kind of an artificial bulwark of sorts, to protect your assets is important. And then of course, some of the entities that you can create can cause there's we say tax savings, and then we say avoid complexity, but you can add to some of your tax due diligence come tax reporting season. And one of the reasons, and we'll get to this as I think as we go to the next slide, it'd be a good idea to just go to the next slide. The complexity is something that we look for to try to avoid. So on the next slide, we'll title it Preserve and Protect. And there we go. We tried to just put things in order of a little bit of like how you would look at these types of things. So Francis mentioned state and federal protections. So any retirement plan that's governed by ERISA really has kind of an unlimited protection. And the idea behind that is, if society allows a creditor to take from your retirement plan, well, then when you come to retirement age, society would have to pay for your retirement. So there's some logic behind protecting ERISA plans. And so various, you want to kind of talk through what, there are different types of retirement plans that are out there, but the big, like ERISA, 401k, 403b type plans, those tend to have unlimited protection. And if you leave a position and you roll those over into an IRA, they tend to have an unlimited protection. And I usually, think it's a good idea to, I left a law firm where I had a 401k, and I put that into a rollover IRA. That's the only account that it is. I'm not going to put any of the traditional or contributory IRA monies that I had saved earlier in my young career into that, so that they don't commingle. Just kind of keep that as like a rollover specific. One of the things we'll see is things like people will often say, "Oh, I put the assets in my spouse's name. Is that okay?" And it's like, well, yes, but you've also like transferred the ownership to someone else. That maybe that's not part of what your prenuptial goals were. And then there's the various types of entities that are more business type entities, and the more you don't have the control, like if it's a single member LLC or you're the general partner, you can tend to have some more liability than when you can say with a straight face, I'm just an investor or a member of that LLC, and there's other people who are affected. So those are some of the purposes why people, like for secondary homes or vacation properties, or even sometimes with, if you're in a state where you don't have a lot of protection on, say, like a investment account, that's not a retirement account. Sometimes folks will, can create an LLC for an investment purpose. There are types of irrevocable trusts. It used to be that the foreign ones were the ones that a lot of people flock to, but in the last 20 years or so, it's become bigger on the domestic side. And we have some folks that work with that. And my theory on a lot of that is the juice worth the squeeze, right? Like, what is the level of net worth that we're talking about and the assets that need to be protected? What's the amount of time and cost and resources you want to put towards that? And is it worth it for you? And in certain cases, we have some clients that we say this makes some sense, and we'll work with the right professionals to get those accomplished. In others, we might be able to kind of go through and come up with a plan to say maybe that's not necessary. So really, the idea behind all of this is in your own particular situation where you're at, it's just good to know that you don't have to rush to any of these things. You should be deliberate, think it through, talk to the people who you trust. If you have your own advisor or planner, that's great. If you don't, you want to talk to someone on our team, that's what we do. So I'll pass it on to Francis for the potential strategies slide.
Sure. Thanks, Jason. And so we've thrown a lot at you already. So let me just organize it if this helps you by style of potential strategies, because I think in terms of principles like this, and it might help you too. So there's those three big silos of ways that you can protect your assets. The first way is having claim paying mechanisms that defend you. So having medical malpractice insurance, having umbrella, having a secondary liability insurance policy, having a good level of underlying automobile and homeowners insurance as well. Those are all terrific strategies that are worth their leverage. As Jason says, the juice is worth a squeeze on this one. So let's get that one right. So just having and delegating the risk and the payments associated with the claim to an insurance company, that's the first set of strategies that I think makes sense. Another set of strategies is the way your assets are titled and the type of assets you have. So 401ks and rollover IRAs, if they came from a 401k and you've got it well documented that it came from a 401k and what the amount was and the time in which it happened, and also contributory IRAs, those are generally protected by states and definitely at the federal level. You don't have to worry about assets that are inside those types of accounts. That has the highest level of protection, just like Jason said on the hierarchy slide on our last slide. In most states, 529 plan assets are protected as well. Those are considered assets of your children, but sometimes our clients go a step further and they make the account owner of the 529 plan their spouse, or say their parents, or an adult sibling of their own, so that they can say, hey, look, I donated the cash to the 529 plan, but I'm not the owner of it. My parents are the owner of it, or, my brother's the owner of it. I'm just the one making a contribution to it. But to Jason's point on the prior slides, it is true that if you made a fraudulent, in anticipation of a claim or a recent adverse outcome, you got a little nervous and you made a big 5 years, worth of gifts to a 529 plan, around the time of an adverse event. And forensics, accounting goes back and said, what's with all this money movement you did recently to put money out of your name? What's going on here? That can come back on you. So having these set up as a regular recurring item, again, getting back to the idea of the physician timeline, this is something you do early and often, not out of season, not out of fear of a recent adverse event. Do this regularly. It doesn't need to be all at once. So that's the 529 plan story. Same thing with life insurance and annuities. Just by virtue of having an investment inside life insurance or an annuity can give it asset protection at the state level. And it just depends on the state and the way that you've got the beneficiary set up or the owners of it. I've definitely seen lots of physicians who say, I'm going to pour some capital into a life insurance contract that my spouse is the owner of, and my spouse is the insured as well, and I'm the income beneficiary to it. And at least then that way, the asset ownership during lifetime is owned by the spouse. Sometimes they have it in an irrevocable trust situation instead as the owner and the beneficiary. So contributory IRAs, you know how you can make $7,000 or $8,000 a year contribution to a traditional IRA? That is a retirement plan, but there is a limit on how much. I think it's roughly $1.3 million right now. I'm sure someone will fact check me and let me know in the chat. But it's roughly $1.3 million. It goes up with inflation every year, so that's why I lose track of it sometimes. But all those accumulations of annual contributions, $7,000, $8,000 a year, going into an IRA, all piling up. Now, the IRA has not been around that long. So if somebody's got more than $1.3 million in an IRA that's not a Roth, and they have it because they've been making those annual contributions, I would like to see their investment strategy. I'd like to learn more about what you've been doing there. So the next item on accounts and titling is tenancy by entirety. This is my favorite, end all be all. I know we have a lot of folks on the webinar who's joining us from Oregon. Thank you, go Oregon. We're about to show you that that is a friendly state when it comes to tenancy by entirety. And a lot of the states on the East Coast are as well. But here's what I want you to remember. Inherited IRAs do not have asset protection. So when you inherit an IRA from, say, your mom or your dad, ironically, it tends to be around the same time in your life that you're at your peak wealth years. You should know that those inherited IRAs do not have asset protection to them. If you declare bankruptcy because you've had an excess, claim beyond the limits of your malpractice policy, then that is not considered a retirement plan with asset protection. So actually just this year, so I'm working with a physician, has a lot in inherited IRAs, but then also has taxable account money too. So, regular brokerage account money too. So what we ended up doing is in their final year of working, when they were at their highest income tax rate ever, we ended up doing a donor advised fund contribution with the net proceeds from doing a full distribution out of the inherited IRA. He specifically wanted to get rid of that risk of losing his inherited IRA in the event of a claim. And I know it's at the end of his career, but there is still issues there. So he was very assertive about wanting to have as little, having no assets on his balance sheet that would be available. And again, there's no such thing about asset protection that's one size fits all. What's a great idea is great for one person, but not necessarily a great idea for you and your family and your finances and your feelings about all of this matter. So this is a very personal thing, and it's really hard to prioritize. And that's why it's great to work with a professional who can sit with you, help you comb through your entire balance sheet, figure out what your priorities are, and then help you decide how to tackle it. So our third list of potential strategies to consider are just plain old contracts or legal entities that take care of it. So we all know what premarital agreements are. Thank you to Hollywood and the news telling us all the time what they refer to. But there's also postmarital agreements too. So this is a case in which, I don't know if you know this, but most people are more likely to experience a divorce than they are to experience a malpractice claim. Just probability wise, the odds are higher for a dissolution of marriage than a fraudulent, than an adverse event, causing there to be a claim. So that said, what some folks want to do and need to do is say, hey, I'd like to go ahead and put assets in my spouse's name, but I want my spouse and I to agree that these are our assets in the event that there is a division. So it's part of the issue of, it sounds like a really safe idea, just place assets in your spouse's name. They're not also a physician. Why not? But sometimes, occasionally, from time to time, that spouse might consider that those assets, they're all mine and do what they want to do with them. And if there's a separation, they have access and they control them. So having a postmarital agreement to outline what the purpose is not unusual at all. Also, there are asset protection trusts. They're kind of remind me of when I was a kid and I used to bury my treasures in the backyard so that nobody could get to my treasures, but then I couldn't remember where the heck I buried them or how to access them. So that's one way to protect assets, but unfortunately it can protect you from being able to access your assets too. So I just say tread lightly on this one. It's not that they're bad. It's not that they don't work. It's just that tread lightly on those. There's control issues there that you might not realize that you were signing up for. Also, limited liability companies. We had a question that came in from one of you that's attending tonight, and the question is, why don't we just put all of our assets in an LLC? What's the limit? What's the downside? Why not do it? Well, reminder that an LLC insulates the rest of your balance sheet from any kind of litigation associated with the assets you put in the LLC. So I think of it like a beer cooler, or a wine cooler. A water cooler, in which you're trying to keep inside the cooler all of the heat or all of the cool that you want. But what it doesn't do for you is it doesn't prevent you from reaching into the LLC and pulling assets out, and it doesn't prevent you from needing to assign some of those LLC shares to somebody who's suing you personally. So from a malpractice insurance perspective, it works sort of, but a lot of times, yes, it will scare off someone who's trying to make claim on your balance sheet, and they realize, well, I don't want that LLC asset. That's not going to do any good for me because I'm never going to get your assets out of it. And I've already mentioned irrevocable life insurance trusts, so I won't belabor that, but it's the same idea with life insurance, just with putting an irrevocable trust wrapper on it too. Okay, so that said, we're getting close to our end time. So let's just go ahead, if you would, and skip on down to titling and registration of assets. And I think Jason, I'm gonna ask you to cover this particular slide, even though it's one of my favorite ones. You go right ahead, Jason.
Okay, yeah. So, one of the things that is important and what, you should look for and have someone, talk through with you is how assets are titled. So sometimes the registration, the operation of law will allow things like if you have a joint tenancy with rights of survivorship, the surviving joint tenant automatically like assumes ownership, sole ownership of an asset when the other joint tenant passes away. But in states that where that's prevalent, and community property is another one that's kind of a relic of the Spanish and French Empire, so it kind of goes from Louisiana to California and a couple other select states. Those don't tend to have much by means of asset protection. There might be certain benefits for tax purposes, so you never know which one exactly makes the most sense for you. We highlight tenancy by the entirety because some of the physicians who are on today's call might live in one of these states where it's an old English type of ownership that allowed, and it only hangs on in about 21 states or so. I can't remember if I have that number right. And what it allows for is that if typically within a married couple, if one spouse has a creditor who lays a claim against them, the other spouse owns that residence, or even in some cases it can be like investment in bank accounts, just as much entirely, so that it's basically an asset protection unless it's some sort of fault of both of the spouses, which wouldn't arise in a professional liability case. So in the circumstances that's an option, that's a great thing to think through and look for. We also see a fair amount of retirees end up in Florida, for example, and having come from a state that did not have it, they'll have it in Florida and some other places that they might relocate to. So wanted to point that out. And in every case, the titling, the registration of the assets, what type of assets they are, your situation can vary. So that's why we want to point this out and say that it's worth thinking through in your plan. And Francis, did you want to follow up with the next steps in the final slide?
Let's do it. So let's talk about next steps. So we've said many times today, consider creating a financial plan with an advisor who's trained on how to advise you on asset protection strategies. So you'll be able to tell when they know what they're doing. But the big thing is to comb through your balance sheet and know what your beneficiaries are and your owners of every asset that you have and how those assets are titled or registered. And then also be able to prioritize with you what you plan to do with those assets during your lifetime in the short term and the long term. And then understand what your cash flow needs are too, to help you prioritize, which of these assets are ones that I should actually give away and put out of my name, and which ones are ones that are worth keeping and how to do it. So another one is your advisor needs to talk with you about your hobbies, need to talk with you about, what activities you engage in. Like, do you own a jet ski? Do you have a trampoline? Do you have a pool? Do you want a pool? Do you have a dock? What kind of water is on that dock? Is it murky? Is it deep? Tell me more. And then also review all of your assets and to be able to isolate, this is your specific exposure. If you were named in a lawsuit today, this is the amount that could be laid claim to. So that's what I do when I go through balance sheets with everybody. The big thing is how much you need. There was a question that came in from one of the registrants, like, how do you decide what is an acceptable limit of umbrella insurance to have? And a lot of times it's once you review the assets and you know what your gap is, then I say at least that amount plus probably your future earnings too, because sometimes when you get sued, you don't just get sued for the assets you have today, you get sued for the assets you're going to have in the future too. So future earnings too. So a good advisor who's well trained and prepared to take you through all that process is what you need to be seeking. And for us, I think the next slide provides you with instructions on how to connect with us specifically. So the QR code sends you straight to my calendar, and you can create a 30-minute quick Zoom call with me to talk through your specific question and help you at least at the first kind of, we'll call it triage level of figuring out what your risk is and probably the direction you need to go in and how you need to prioritize it. Reminder, I do not give legal advice. Fundamentally, asset protection is a legal a tax, and it's an investment, and it's also an estate planning issue. So you want somebody who knows how to pull all those issues together all at once. And we're excited to be able to work with you and help you on that. We also have on the next page access to our physician planning resources. We have created a series I mentioned earlier at Curi Insurance, a litigation education series. You can use the QR code to the right in order to access that website. First off, you will find videos. I think my video is 30 minutes long, in which I pretty much talk about everything we just talked about today, but in a slightly different format. And also then on the left, you'll see a QR code that takes to the Curi Physician planning resources. So these are articles and videos for those of you who, as you know, Curi is short for curious, and we know our physicians are curious and they love and they are able to do a lot of this themselves. And it's only to the point that you get at where you say, actually, I think I need somebody else to get a second opinion with me on where I think I'm heading on this. But this is a terrific place to start so that you've got just the vocabulary, the knowledge, and it starts to activate some motivation in you to decide what you want to do next. All right, so with that, I think we can leave on this slide, and then Dimitri, can you tell us which of the questions we were asked by the registrants and what came in that maybe we need to address?
Definitely. Thank you. You both did a great job. So one question that came in was around medical malpractice insurance coverage. And it's a multi-part question. Jason, I'll ask this of you. Does it make sense to get more primary coverage? Is excess coverage the answer? Is all of that discoverable? What about higher limits? What's the best way to approach having enough coverage, but also protecting personal assets?
Yeah, that's a great question. In a lot of cases, in most states, there's like a statutory amount of coverage that's expected, and so that's where I referenced like the $1 million in Colorado. That tends to be the starting point where a lot of malpractice or insurance carriers, professional liability will offer. I will say that it obviously, when you get to the point of discovery, if you were to have a higher coverage amount or a higher policy limit. So I was aware that there were some practices that I knew that would, double it to say 2 million. It does potentially, have this adverse effect of having a deeper pocket potentially. And is that a good or a bad thing? And I don't have the answer necessarily, other than to say, I think it's something that the folks at Curi Insurance would really want to get into that conversation and talk that through. There are other potentials to protect your personal assets outside of the fundamental policy, like we talked about. But yeah, I think that's a great question, and not necessarily answerable, with just a distinct, yes or no, but worth talking through some more. So from whoever asked that question, I think it would be great to do some follow-up.
Thank you, Jason. Francis, I'll direct this next question to you, and I'll kind of position it in a two-part question on this journey financial continuum, if you will. If somebody is in the early stages of their career, they're just starting out, or they're 2, 3, 4, 5 years into their career, where do they start? Where does that profile start with regard to asset protection as they're accumulating? And then I'll marry that with a question that also came in during the presentation. Now somebody has completed their career, they've put forth proper asset protection, they are retired. How long after retirement does one need to maintain those asset protection measures?
Thank you. That's a great question, Dimitri. And I'm glad you brought it up because I never did talk about disability insurance. So here's the thing, in the early stages, and maybe we should go back to the timeline if that's okay, on the slide to reference this. So in the early stages, when there's debt accumulation, it's tempting to think that you don't really have any assets to protect, but you do. Your career is your asset. Your human value is your asset. So a lot of your value is embedded in you as a human, and you are just that, a human. So having disability insurance as a priority for early stage in your career, and I would emphasize, please, after you finish your residencies, I say C's because so often there's more than one, and fellowships and et cetera, that you get a disability and policy that speaks to your specialty in medicine specifically. Not, it's great to have something that covers any occupation or your own occupation, but you got to go deeper on own occupation definition. You need to read the section in your disability contract that specifically says, what is your occupation? How do we define your occupation? Because if you're an orthopedic surgeon and you get tremors in your hand and you can no longer perform surgery, but you could retrain and be a psychiatrist, I can guarantee you're going to have a different type of income as a psychiatrist than you did when you were a surgeon. So it's very important to address your specific specialty in medicine. Obviously, having the right amount of life insurance, the right type of life insurance also makes sense. Sometimes that's harder to prioritize when you're paying down debt and when you're taking out your first mortgage, especially if it's a large mortgage and it's kind of a family home at that point, because a lot of times physicians are in their 30s and have a family when they really start their careers. So I know that's difficult to prioritize, but I think that's probably the most overlooked issue because they don't necessarily consider that they themselves are an asset to protect as well. And then end stage career, I think your question was, how long do you do asset protection after you're in that wealth transfer phase and after you're at the high, the peak accumulation years? And a lot of it is the statutes of limitations in your state that governs, whether or not litigation is a concern. Obviously, Curi offers tail insurance to you, so making sure you have that tail insurance, making sure that you've got that's accessible to you, it's in your own name at that point, is the next kind of important phase during the wealth transfer. But don't forget, asset protection isn't just because of you're a physician, it's also because you're a homeowner. Sometimes you're a landlord and you're an auto driver. And sometimes you operate a boat. So it's important to have asset protection perennially because you are going to be living the lifestyle of someone sometimes that the rest of the world assumes that you have high dollars because you are a physician or you once were a physician, you're a retired physician, and there is a social assumption that you're very well educated and you're very knowledgeable, you must have a lot of money. And so protecting your assets at all those stages are still relevant. They just take a different form. Dimitri, did that answer what you had in mind for that question?
Yes, thank you, Francis. So next question. Earlier on slide 12, where we showed some potential strategies, we hit on 401k plans, we hit on IRAs. There was a question that came in from the audience specific to cash balance plans. Do we have any additional context on what type of protection cash balance plans offer those who have assets in those types of plans?
Yeah.
Go ahead, Jason.
I was just going to say, typically a cash balance plan goes through the ERISA statute that has the same protections. So provided it's an ERISA cash balance plan, it has the same absolute protections. You'll sometimes see those roll over into IRAs post employment as well, where they would maintain that rollover protection. So those should be protected. Of course, you'd have to look to the actual plan and make sure, but that would be a general answer.
That's great. And I remember
And I'll
from
go ahead.
personal, oh, go ahead, Francis.
It's funny, last week I had a 70-year-old physician who I was making, I think, $700,000 a year, and they were living off of their earnings, understandably, and they also had accumulated a lot of assets inside their brokerage account. So I had said they were self-employed, and we talked about doing a cash balance plan, and I showed them the illustrations, and they could put $300,000 a year into a cash balance plan based off of their age and income and so forth. Well, the objection was, but I need to live off of my income. I can't defer $300,000 a year pre-tax into a cash balance plan. But we worked out a deal where they could live off of their unprotected assets in their brokerage account for those final years, thereby essentially kind of funneling money from their brokerage account into a cash balance plan, just by now you're living off of your brokerage account, not just your income. So, and that ended up working for that physician as an idea. But again, every idea that's good doesn't mean it's good for you. But that was a case, Dimitri, getting back to your earlier question, what do you do in your late stage to do any kind of asset protection? Sometimes it's not too late. Sometimes you can employ those big opportunities too.
That's right. That's right. Well, I know that we want to be respectful of everybody's time. And in those slides towards the end, we've shared QR codes where those of you who've dialed in live or those of you who are listening on the recording can access our team. There were a number of questions this evening around excess coverage and larger limits and whatnot. Our colleague, Dr. Damian McHugh, who's at Curi, has put some helpful guidance in the chat here. If you have any specific questions around your med-mal coverage with Curi, the two best people to talk to are our colleagues Jim Kay, if you work with Curi directly, or Amber Pompum, if you work with a broker partner of ours. They have that area of expertise much more than Francis, Jason, or I do. But I want to thank Francis. I want to thank Jason. I want to thank all of you for spending time with us during this call, those of you who took time to listen to the recording. And we are here to help you and here to serve you. We appreciate your partnership, and we hope you have a great day. Thank you.
Thank you.